24 CF 588, Your Honor. The state's requesting a continuance because there's an outstanding FDLE report.
Okay.
So we're requesting that to be continued to the September 9th docket for pretrial.
And the entering of this plea, if it has any adverse consequences to Mr. Rogers regarding what he may be sentenced to on the new case, you've talked to him about that?
Yes, Your Honor.
Okay, thank you.
If I may approach.
Yes, sir. Mr. Rogers, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Rogers, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Rogers, I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months in the Okaloosa County Jail with credit for all time served. That's to run concurrently, run at the same time between each case and count. You need to pay the $200 cost of prosecution, $250 public defender's fee. Your current supervision is revoked and terminated. So when will I see Mr. Rogers again on the other case?
On the September 9th docket.
Okay. Mr. Rogers, I'll see you on September 9th on your new case, okay? Thank you. Yes, ma'am.
Yes, sir.
Mrs. King came back, with Mr. Koch.
Oh, okay.
There's a problem with the Joanne Bird Center. They cannot intake her on a Friday. They can only intake her on Monday. So we're gonna have to do the bars to bed till Monday.
To be released on Monday.
Yeah, I just talked to her and.
Oh, okay. Mr. Koch, you okay with that?
Yes.
She's, I believe, already gone back downstairs. I'll have to get her back up here.
They have, I guess they're state funded and they have to
Yes,
have.
It-
It all.
If you can get her back up here, that'd be great. Okay? Thanks, Ms. King. They'll bring her back up and I'll call her case. Okay? Thank you.
I'm so sorry.
Eddie Rogers is next.
Thank you. Hello, Mr. Rogers. Who's in the gallery for you, Mr. Rogers? Mr. Rogers? Who's in the gallery?
That's not for him, Judge.
Oh, I thought you were waving at someone. Okay. Thank you.
Waving at someone.
Oh, okay, gotcha. Okay, thank you. Mr. Koch?
Yes, Your Honor. We're here on two cases, the 24 CF 395, the 24 CF 1416. We got to this position for plea or continuance just to get some offers, and I did get offers from both cases. I spoke with Mr. Rogers at the jail yesterday. I'm requesting both cases be kept together and moved to the September 9th date, Your Honor.
Okay. Mr. Rogers, I'll see you no later than September 9th.
Okay, thank you.
Thank you, sir.
Next, we're going to do Stephen Rogers and Mr. Cobb.
Thank you.
All right, Mr. Rogers, you have the floor.
Hello, Mr. Rogers. Mr. Rogers, Mr. Cobb's on the screen, okay.
Yes, sir.
Mr. Cobb?
Yes, sir.
What do you want?
Yes, sir. Oh, sorry, Judge. Jason Cobb on behalf of Stephen Rogers. Judge, I filed a reciprocal discovery. There was a witness that Mr. Rogers had informed me about that would provide what I believe to be exculpatory testimony, but I didn't immediately just list the witness in a reciprocal discovery. I spent time vetting the witness to make sure that what the witness had to say was true, correct, and accurate. So when I finally determined that this witness would be productive for the defense, I notified Mr. Snell and I filed a reciprocal discovery exhibit. And I just got the address of this witness, and I'm going to file an amended reciprocal discovery exhibit. So I don't know if the state wants to take her deposition, what to do, but I understand that we're scheduled for trial and that it's probably not the most fair thing to spring a witness upon the state the week before scheduled to go to trial. So I leave it up to Mr. Snell to decide what he wants to do.
I would
Mr.
definitely
Snell?
need to talk to this witness. Yes, sir.
Okay, so you're seeking a continuance?
Yes, sir.
She's here now.
Okay. When you say talk to the witness is present in the court?
Present right now in the
Well,
gallery.
I would like to take her deposition and put her under oath, for sure.
Okay. Mr. Rogers, I have to be fair to the state.
Of course.
Same way.
Due process.
So, yes, sir. Good. So I'll see you back here. We'll continue it until September 9th. Will be the pretrial. How long would it, I mean, do you see being able to accomplish it any sooner, Mr.
What I'm
Snow?
going to do is go back and talk with my assistant at the office, and we'll find some time really quick to see if we can get her in and take the deposition. It shouldn't take very long, I think.
How long was it going to take to try Mr. Rogers' case, including jury selection?
Maybe a day, but I would be on the cautious side and say 2 days.
Okay, because I was wondering about the Friday, August 9th, but if it takes 2 days, then that wouldn't work.
Right.
Okay. So, Mr. Cobb, any objection to the continuance?
No, I don't object to it. I think it's fair. I think it's what the state's entitled to. And then once we get this deposition taken, there'll be nothing that prevents us from going forward.
Yes, sir.
If we
Okay,
could
Mr. Rogers, I'll see you no later than September 9th.
If we could set the 22 CF 1342 on either your 12 or 15 date, and go ahead and have a sentencing on that case.
Can't be sentenced on a VOP without being sentenced on my trial first.
Well, I can if you've already entered a plea on the VOP.
No, he had a,
Judge, we had an evidentiary hearing and the court found him guilty of the violation of probation.
Okay,
But the points are different with the new charge, new law violation. My points add up to 84. I have to finish.
well, then as far as his score sheet wouldn't show anything regarding 23 CF 1804 because he hadn't been convicted, correct?
correct.
That's correct, Judge.
Okay. So, Mr. Rogers, I can sentence you on the VOP. It just won't appear on the score sheet, any new charges, okay? So when do you want to set that?
Either your 12th date or your 15th date,
Okay,
whichever
let's do it
is the...
August 15th. You want to do it in the morning or afternoon?
Afternoon.
Okay? So August 15th at 2:30.
Thank you, Judge.
Thank you. Thanks, Mr. Rogers. I'll see you August 15th.
Bless you,
Okay?
sir.
Thank you, sir.
Bring Timothy Jordan next.
Yes.
Hello, Mr. Jordan. Mr. Jordan, Mr. Cobb's on Zoom.
Yes, sir. Judge Jason Cobb on behalf of Mr. Jordan and 2021 CF 2345, 2023 CF 1983. If the court would give me a little bit of leniency, I'd like to explain a situation that's occurred in Mr. Jordan's case. Last Friday, I spent a considerable amount of time working out a plea negotiation with Mr. Jordan to 36 months DOC with credit for 745 days time served. I did this while the majority of my family was at a reception in Sundance. So after I worked this out, Mr. Jordan said that he would accept the state's offer, the 36 months DOC. I shut the file down, called Mr. Gomez, told him it was going to be a plea agreement. Of course, based on my representations to Mr. Gomez, the state canceled its subpoenas. And so then
Hold on,
yesterday...
Mr. Cobb, hold on. Kind of have, Mr. Gomez, kind of makes the court a little uncomfortable that you're talking directly to a represented party without his attorney being part of that.
Mrs. Brown is saying the same things as Mr. Cobb had already talked.
Okay, but I mean, if you're muting that mic, it just, hold on. I just want to make sure, because that bothers me. I just want to make sure. Probably nothing improper at all, but just the appearance of that. So if you'll wait, whatever conversation y'all have, have it on the record and make sure Mr. Cobb can hear it. So, Mr. Cobb,
Yes,
what do
sir.
you, so you're saying?
What I was saying
because of
was-
that is that the states canceled their subpoenas and they're not ready for trial?
Right, and I basically shut down too and went ahead and enjoyed the rest of the weekend's festivities. And so then when I got some text messages late last night that Mr. Jordan had changed his mind and did not want to accept the state's plea offer. So if we've reached this point where he doesn't want to accept the plea offer, I don't think the state has any choice but to request a continuance, and I don't have any
Hold on, Mr.
any
Cobb.
basis to object.
If I can speak, I will apprise the court of what Mr. Jordan had just said to me. He was simply requesting, why can't we do a suspended sentence? This is what I will do right now, because we canceled subs, and everything that Mr. Cobb just stated was 100% correct. We had an agreed-upon plea agreement to 3 years in the Department of Corrections. I want to let this court know that the score sheet shows 105 months. This is a significant, we have come down significantly to try to reduce this case. I will not agree to a suspended sentence. What I will agree to, and you have to take it today or everything is off the table, is that you do what's called a reverse split, which means that there is no question of do I serve the sentence or not. You will do 3 years of probation, followed by the 6 months. If you complete probation, then followed by the 6 years. If you complete probation, then the 6 years goes away. If you get a technical violation on probation, and we find you guilty at a VOP evidentiary hearing of that technical, you will serve those 6 years. So it's the same thing, it's just not called a suspended sentence. It kind of takes the decision out of the court's hands as to whether or not to impose those 6 years. But I'm telling you right now, Mr. Jordan, if you get a technical violation and you get found guilty at a VOP evidentiary hearing, it will be those 6 years. And you will get credit for the time that you've already served in here. So
From July the 1st of 2022,
I
right?
think it's that 745 days that's
You're
listed in
correct.
there. You will get that credit if you commit a technical violation or are found guilty at an evidentiary hearing, but it will be the 6 years minus the 745 days of credit.
I
You
agree
have
to
take
that.
today.
I would take that today.
And Your Honor, there are, if I may, there are some cases that we're going to be dismissing as a part of that. And I can try to write that out. And we're agreeing to this because, we understand that this has been delayed. Our FDLE expert, to be quite frank, would not have been available for trial. We had subpoenas out. When I got the notice that we were going to take the WPA, then we canceled the subs. And so
Yes, sir.
that's why we're agreeing to this. And I need Mr. Jordan to know this is the absolute best that it's going to get.
And so that sentence applies to count one only? What count does it apply to?
Judge, I think I can read it out, AJ. I've got it written down. I can read it out.
Okay. I just want to,
Yeah.
that you're aware, Judge, this is going to encompass 23 CF 1983
Yes, sir.
and 21 CF 2345. This is to get all of Mr. Jordan's cases off the docket.
Okay.
The state, and Mr. Cobb can read what, because he had sent me a text message. We're going to null pros count 2 in 21 CF 2345 and count 2 in 23 CF 1983.
Correct.
And all the other counts would be the 3 years probation followed by 6 years DOC?
Right, except for the misdemeanor to just be time served, Judge.
Thank you.
Well, 1129, because that's as much as you can do on it.
We'll put it on the record.
Well, how about we just say time served?
Yes, sir, that's fine.
Oh, yeah, on any of them, yeah, that's fine.
Okay.
And Judge, because I'm not trying to set Mr. Jordan up for failure, there's a hefty fine on that, the count one.
Okay.
Well, actually, I'm sorry, I'm gonna take that back. We're gonna have to do, because it's a trafficking, we're gonna have to do a sale, manufacture, deliver on that. On count 1 of 23 CF 1983, it'll have to be a lesser included sale, manufacture, deliver, which will take away the fine.
Okay.
Mr. Jordan, I advise you not to say anything else than to accept this gracious offer smilingly, willingly, and let's get it over with.
We're working the rest of the details out. That's all we're doing.
Yeah, you don't do that, I do that. I advise you to sit there and say yes, sir, no, sir, and let's get this done.
Okay.
And Crystal, on the count 1 on 23 CF 1983, the lesser included is going to be 893-131A1.
Mr. Jordan, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. If you'll put your hand down. First off, Mr. Jordan, you seem very happy.
Well,
I mean, you seem pleased with the outcome of this.
I'm done, you know.
Yes, sir.
I've been in prison 4 times. Every time I get out of prison, I ain't got nothing holding me down. What do? I go out there and get in the same thing that I did last time.
Okay, so let's talk about the plea. Are you currently under the influence of any drugs, alcohol, or medication?
Nope.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
I went to the 10th grade, but I got a GED.
Good. I know that's self-motivated. Congratulations.
Yes, sir.
Mr. Jordan, has anyone forced, threatened, or coerced you into entering the plea?
No, I pretty much made this plea.
Okay. So here's what I understand the sentence would be, and I'm going to announce it, and then if you say, yep, that's what I want to do, then I'll say that's what the sentence is, okay? It's my understanding that it would be an adjudication of guilt in both 23 CF 1983 and 21 CF 2345. Counts 2 in each of those cases would be dismissed. It would be a lesser included offense on count 1 in 23 CF 1983. You'd be sentenced to time served in the misdemeanor counts, and all the felony counts, they run concurrently, run at the same time. You'd be sentenced to 3 years probation, followed by 6 years in prison. And that means there is no discretion with the court. If you violate probation, you would be sentenced, you'd go directly to DOC, and you would get credit for 745 days. So do you understand that part?
Yes, sir.
You'd have to pay court costs in both cases, total of $250 public assistance fee and $40 per month cost of supervision.
And Your Honor, Mr. Cobb, what I'm showing Mr. Jordan right now, and just so that I can let you know, in the score sheet that I'd originally sent you, we had the primary offense being that trafficking. I essentially crossed that out, so it took the primary offense from a level 7 to a level 5. It takes the 56 points down to a 28. I then just did the math on the rest of that. I'm showing Mr. Jordan as well so that he understands it. It takes that 172 down to 142. And then over here, takes the points down to 85.8. It is still a downward departure, Your Honor.
I got to sign it.
No, this is just a score sheet. I just wanted to make sure that you were completely aware.
Okay.
We have statutory grounds for downward departure based on some cooperation that Mr. Jordan did in another case, because I can't really say it's a legitimate uncoerced plea, because it's not. It's he did cooperate in another case and testify, and it led to a conviction of a defendant.
Just checked, but because this
Is the possession of a weapon by a convicted felon, is there a mandatory minimum?
no, Your Honor, not on this. This is going to be constructive possession, Your Honor.
Okay. Thank you. Thank you, Madam Clerk. So, Mr. Jordan, is that what you wish to enter this plea?
Yes, sir.
Okay. Do you have any questions for me or Mr. Cobb or the state?
Nope.
Mr. Jordan, then that's your sentence. Thank you, sir. And you'll need to report to probation. If you get out before 5 o'clock, you need to report at 5. If it's after 5, at 8 in the morning. Good.
What town is he living in?
Okay. Thank you.
And Judge, if I may, I'd like to express my appreciation to the court and to the state for allowing me to try to balance my personal life with my work life. I know it hasn't been very easy, but I'm very, very appreciative.
Thank you, Mr. Cobb. We appreciate that. Thank you,
Okay,
sir.
have a good day, everybody.
You too. Yes, sir, Mr. Koch. Right? Okay. So there was a change. Your mom said that the receiving, the and I can't remember the name, but there you go. The Joanne Burge Center doesn't accept anybody on Fridays, so it would be on Monday. Do you still want to enter that plea?
So will I not be getting out till Monday, or will
Correct.
I get out
Nope.
tomorrow and be there on Monday?
No, you'd get out on Monday at 7:30, 8 o'clock at probation, and then immediately after probation be at the center after that.
Yes, Your Honor.
Okay. I know that's not what you wanted, but that's the only way to get the variables out of there.
Okay.
Okay? Thank you, ma'am. Good luck to you. And thanks to your mom. Thanks, Miss King.
Judge, next we'll do a manual colleague. Did Mr. Cobb leave soon?
You did?
He had 2 more inmates.
Okay.
Hold on, I'll message him real quick, Your Honor.
Okay.
He'll be back on.
So I guess we will not take the manual colleague right this second.
Okay, yes, ma'am. Okay.
So we'll do Michael Rona next.
LaPella, you ready? Yes. Okay. Rachel, we're going to take Mr. LaPella's case, okay?
Sean LaPella for Simon Ward, present, approaching, 23 CF 1039. Thank you for the court's patience.
Yes, sir.
We're working to an agreement. We have it 90% done. We'd like to come back this afternoon and see if we can finalize it. I've just got a couple terms I got to talk to Mr. Snell about tweaking. Is it 2:30 would be the appropriate time?
Yes, sir.
Okay, we'll be back at 2:30 if it's okay with the court.
Mr. Ward, I'll see you at 2:30, okay? Thank you.
Thank you.
Someone once said herding butterflies.
That seems way more happy-go-lucky and jovial than this, I'll be honest.
Okay. He's back.
Yeah. Mr. Cobb, you were so pleased with that last outcome, you forgot about the other two.
Yeah, I had a little senior moment there for a second.
Yes, sir. I think Mr. Colley's coming out. Mr. Colley, Mr. Cobb's on Zoom. Mr. Cobb, what do you wish to do with Mr. Colley's case?
Yes, sir, I know I was recently appointed to represent him, Judge. I'll be back in town on Saturday, so I would like to ask for a continuance so I can have time to talk to him about the case and the charges.
Okay.
September 9th is what I'm asking for.
Yes, sir. Mr. Colley, I'll see you back here no later than September 9th.
Judge, she also has a case on the docket under Katie Jakewitz.
She filed a motion to withdraw on the 15th, but there's been no order to follow yet.
It's number 20 on my docket.
Okay. Okay. Then, Mr. Colley, I'll look at that motion. If I haven't already signed it, then I'll sign it, and I'll appoint Mr. Cobb to represent you on that case, okay?
All right.
Good, thank you.
Thank you, Judge.
Next we have Isaiah Luna.
Hello, Mr. Luna.
Yeah, how you doing?
Good. Mr. Cobb's on the Zoom. Yes, sir, Mr. Cobb?
Yes, sir. Judge Jason Cobb on behalf of Mr. Luna. Judge, it's a similar situation. Another court appointed me, I believe, on the 11th, if I'm not mistaken. But I haven't had a chance to really look at the case file. I read over the arrest report on the plane, actually, and I'm asking for a September 9th continuance, and as soon as I get back into town, I'll go see Mr. Luna at the Okaloosa County Jail and discuss this case with him.
Okay. Mr. Luna, I'll see you no later than September 9th. Mr. Cobb will come up to see you in the jail.
Yes, sir.
Thank you, sir.
I appreciate it.
Thank you. Thank you, Mr. Cobb.
Now, I think that is it, Judge. Is that it?
As long as Rachel says that she said yes, sir, you can leave. Thank you, sir.
All right. Thank you, everybody. Have a good day.
You too. Okay. Have anybody else in back? Plenty more? Well, then let's take a 10-minute recess, and then we'll come back and finish up in the morning. Thank you.
All right, please.
Please give us a call. We're here to help you out.
Congratulations, Crestview very own Dixie Dan Powell of Powell Injury Law for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers.
Your Honor, I have Joshua McAllister. He is on the 1:30 docket, but he is present today, this morning.
Yes, sir.
And this is case 24 CF 1361. We do have receipt of a 2-count information. We will waive the formal reading, enter a not guilty plea, and just ask that this remain on the September 9th docket.
Okay. Mr. McAllister, I'll see you back here on September 9th at 9 o'clock. Stay in touch with Mr. Kleins.
Yes, sir.
Thank you, sir.
Have a good day.
You too.
It should be Sarah's case, Mr. Michael Rhoda. Your Honor, this is Mr. Devin Stevens in 24 CF 99. If I just may have one moment.
Yes, sir.
please.
Your Honor, this is a case I'm going to file an amendment.
Okay, thank you.
it's after this date, it should be acceptable. No, because this incident happened before. So,
Thank you, Judge.
Yes, sir.
This will be a change of plea this morning. Ultimately, count 3 battery is going to be null pros by the state. So starting with count 1, it's going to be amended to felony battery. Florida statute 784.03 subsection 2. And count 2, Your Honor, is going to be the lesser included resisting officer without violence, the Florida statute 843.02. Count 1, Your Honor, will be a withhold of adjudication, 36 months standard probation, has the $40 per month cost of supervision. There's a 967 court costs, 150 defense costs, 24 hours community service, maintain gainful employment, or 5 job applications per week. There's no contact with Eddie Duran Jr., must complete the anger management class, and there's the mental health evaluation with any recommended treatment. Count 2, the lesser misdemeanor, is going to be adjudication of guilt, credit for time served. And like I said, count 3 is ultimately going to be null pros, if I may approach with the plea form,
Yes,
Your
sir.
Honor.
Mr. Stevens, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Stevens, did you read the plea agreement?
Yes, sir. Yes, Your Honor, I did.
Good. Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, we did.
Did he answer all of your questions?
Yes, he did.
Are you satisfied with his representation?
Yes, I am.
Did you sign the plea agreement?
Yes.
Mr. Stevens, I do accept your plea to the amended information on count 1, lesser included on count 2. Count 3 is dismissed. On count 1, adjudication is withheld. You're sentenced to 36 months probation. You need to pay the $40 per month cost of supervision, the court costs, $150 public defender's fee, perform 24 hours of community service work, obtain gainful employment, or perform 5 job applications per week. Have no contact with the victim. You will need to enter and successfully complete the anger management class and submit to a mental health evaluation within 30 days from today. If any treatment's recommended, begin that treatment within 60 days from today. On count 2, it's the lesser included offense. You're adjudicated guilty. You're sentenced to credit for time served. Mr. Stevens, I wish you the best, sir.
Thank you so much, Your Honor.
Thank you.
Ethan Sanders, Judge.
Thank you. Hello, Mr. Sanders.
Good morning. How are you doing, sir?
Doing well. How are you?
I'm good, sir. Your Honor, may I just have a brief moment?
Yes, sir.
Brief moment? Sign that, and today is the 18th. Your Honor, we're here in 23 CF 1862 for a violation of probation and 24 CF 348. In 23 CF 1862, counts 1, 2, and 3. And in 24 CF 348, counts 1. It's going to be an adjudication of guilt, 9 months in the Okaloosa County Jail, credit for time served. This will be followed by 2 years of standard probation, $40 per month cost of supervision, $100 cost of prosecution, $615 in court costs. There's $250 in defense costs, substance abuse evaluation within 30 days, and any recommended treatment to begin within 60 days. No alcohol, no drugs without a valid prescription, random UAs, random breath tests, 24 hours community service, and gainful employment or 3 job applications per week. In 24 CF 348, count 2, the misdemeanor is going to be adjudication of guilt, credit for time served, all cases and counts to run concurrent. If I may approach with the plea form, Your Honor, and the score sheet.
Yes, sir. Thank you, sir. Mr. Sanders, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Sanders, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Very.
Did you sign the plea agreement?
Yes, sir.
So is the score sheet that I have to the state, is it accurate, 18.825, or is that before the amended? Okay, so it's a downward departure? Thank you. Mr. Sanders, I do accept your plea. You're adjudicated guilty in each case and count. You're sentenced to 9 months in the Okaloosa County Jail with credit for time served. That's on counts 1, 2, and 3 of 23 CF 1862 and count 1 of 24 CF 348. Followed by 2 years of probation. You'll need to pay the $40 per month cost of supervision, $100 cost of prosecution. There are court costs in the new case. You'll need to pay those, total of $250 public defender's fee. You'll need to submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today. No, 30 days from your release from jail. And 60 days from your release from jail. You'll have no alcohol and no drugs without a valid prescription. You'll submit to random breath test, random urinalysis, perform 24 hours of community service work, obtain gainful employment, and until you do that, you'll need to do 3 job applications per week. So counts 4 and 5 of the VOP, that wasn't part of the VOP?
That was previously addressed, Your Honor.
Okay, good. Thank you, Mr. Sanders. Good luck to you, sir.
Thank you.
Prior supervision of both attorneys.
Yes, ma'am.
Yes.
Thank you.
I believe yes, we already entered that plea.
So this might be Rona?
Correct. I believe that's before.
Mr. Rona?
Judge, this is Mr. Rona. Can I have a brief moment, Your Honor?
Yes, sir.
That's what I thought. Thank you, Your Honor. Today. Okay. Your Honor, this is Mr. Michael Ronan, 23 CF 1819. This case I was originally on, and then Mr. Arrowwood took over, then I got placed back on.
Yes, sir.
I received all the discovery from the state attorney. I printed it all out and brought it to my client yesterday, and we got kind of up to date on this case. Your Honor, I'm seeking a 1-cycle continuance. I have 1 deputy that needs to be deposed. And other than that, in that case, it'll be geared up, ready for trial. But that's the only thing outstanding. So I'm requesting that 1 cycle to 9/9, Your Honor.
Okay. Mr. Rona, do you understand what Mr. Koch is doing in your case?
Yes, Your Honor.
Do you agree to the continuance?
Yes, Your Honor.
I'll see you back here no later than September 9th.
Thank you. God
Thank you, sir. Thank you. Hello, Mr. Strunk.
Good morning, Matthew. Your Honor, may I just have a brief
Yes,
moment?
sir.
If you want to. Thank you, Judge. This will be a change of plea this morning. I'd like to start with count 1 is going to be the lesser included of sell, manufacture, deliver, possess under Florida Statute 893.13 sub 1 sub A. Also, count 2 is going to be the lesser included of the same statute of sell, manufacture, deliver. Counts 3, 4, 5, and 6 will all remain the same. So for the terms of the plea, Your Honor, counts 1, 2, 3, and 4, adjudication of guilt, 36 months of standard probation. There's the $40 per month cost of supervision, $615 in court costs. There's $150 in defense costs. Must successfully complete the Phoenix House program, which will be bars to bed. No possession or consumption of alcohol. No possession or consumption of drugs without a valid prescription. Random breath tests and random UAs. All counts run concurrent. Counts 5 and 6 will be adjudication of guilt and credit for time served, Your Honor. If you could just date, today is the 18th. Thank you. And Your Honor, may I approach with the plea form?
Yes, sir. Mr. Strunk, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Mr. Strunk, did you read the plea agreement?
Yes, sir, I have.
Do you understand it?
Yes, sir, I do.
Did you discuss it with your attorney?
Yes, sir, I have.
Did he answer all of your questions?
Absolutely.
Are you satisfied with his representation?
100%.
Good. Did you sign the plea agreement?
I did.
Mr. Strunk, I do accept your plea. You're adjudicated guilty to the 2 lesser included offenses and 1 and 2 as charged on the balance of the counts. On counts 5 and 6, you're sentenced to credit for time served. On the other counts, you're sentenced to 36 months probation. As a condition of that, you'll need to enter and successfully complete the Phoenix House Inpatient Treatment Program. It'll be bars to beds. You'll need to pay the $40 per month cost of supervision. That'll be waived while you're in the Phoenix House. You need to pay the court costs, $150 public defender's fee. Submit to random breath test, random urinalysis, have no alcohol, and no drugs without a valid prescription. Anything that I missed for Mr. Strunk?
No, Your Honor. Because the lesser included offenses, I don't have an up-to-date score sheet,
Yes,
but
sir.
this will be a downward departure.
Okay, thank you. Mr. Strunk, I wish you the best. Phoenix House will probably be tough, but if you come out, you got the rest of your life. So I wish you the best, sir.
Yes, thank you, sir.
Thank you.
All right, Matt. Good job. All right, best of luck.
John, anyone else?
Yes, sir.
Your Honor, this is Mr. John Summerall in 24 CF 1031. Just to get everyone up to speed, this was the first time up on the pretrial docket in July. At that time, I didn't have any discovery or any offers. The state did provide us with discovery. I provided my client with a copy of everything yesterday.
Good.
At this point, we are seeking a one-cycle continuance to that 9-9 docket for pretrial, Your Honor.
Okay. Mr. Summerall, I'll see you back here no later than September 9th. Thank you, sir.
Yes, sir.
Timothy Freimeyer, Smith.
Hello, Mr. Freimeyer.
Mr. McKinney, on behalf of Mr. Freimeyer in 20 CF 1932. And Judge, I'm going to ask for this to be reset. It's a violation of probation. The state has made an offer that's in Department of Corrections. I'm trying to piece together the credit amount between Okaloosa, Walton County, and a Department of Corrections sentence to nail down a credit amount in hopes of getting the state to agree to a specific amount. I don't have that number to sit down and go through with Mr. Snell, but it shouldn't take me too much longer to get that. So I'm going to request that we bring Mr. Freimeyer back on the 12th of August without subpoenas. I do believe that we're very close, but I want to make sure that we get all the details right.
Okay. Mr. Freimeyer, I'll continue your, well, no, we'll just set it. Right, we'll just set it for August 12th at 9 o'clock. I'll see you no later than then.
Yes, sir.
Thank you, sir.
Next is Justin Tipton, who's also on the 1:30 docket.
Thank you. Hello, Mr. Tipton. Good, how are you? Good.
Mr. Tipton is before the court in, I think, a total of 4 cases today. He's got 2 violations of probation, which is 22 CF 1419, 23 CF 331, which we'd set over to today to really match the arraignment date to see if an information's been filed. And I'm going through what I've been handed in 24 CF 1359 would acknowledge the receipt of a 1-count information and waive its formal reading, enter a plea of not guilty. And I'm going through 24 CF 1278, which is a 3-count information, will waive its formal reading, enter a plea of not guilty to that as well. Judge, given that I was handed those today, I'd like to bring all these back on September 9th for all 4 of Mr. Tipton's cases. If we reach a resolution ahead of time, which I'm certainly hoping that we do, then we can always add this back to an earlier date in August.
Absolutely. Mr. Tipton, I'll see you no later than September 9th.
Yes, sir.
Thank you.
Michael Wagner is next.
Thank you.
On this count, we charge you 1 count related to a bank check. This one they charged you with 1 count of a vehicle, unaccountable. That's primarily what I want to look at. I want to talk to you and see what we can get worked out on that. Okay? As soon as I get my feet under me on that, then I'll come talk to you for a second. Thank you. Judge, this is Michael Wagner before the court. Mr. Wagner is here in 24 CF 856. We had passed it over to today to see if we could resolve the matter. At this point, I've discussed it with Mr. Wagner. The state's offer includes an adjudication of guilt to a felony. He's concerned about the adjudication to a felony, so I'm going to request a continuance until the September 9th date so that I could work with the state in getting the remaining discovery and move forward in that fashion.
Okay. Mr. Wagner, do you understand what Mr. McKinney's doing on your case?
I think so, sir.
Okay. Do you agree to the continuance?
Yes, sir.
I'll see you back here no later than September 9th. If the state offers you something before then that you want to accept, Mr. McKinney can set it for a hearing. Thank you, sir.
And for the record, I did convey the state's adjudication and 6-month offer to Mr. Wagner, and he indicated that he wishes for me to proceed forward in trying to work through the case. His concern was primarily the adjudication.
Okay. Thank you, sir.
Steve Willis is next.
Judge, this is Mr. Stephen Willis before the court in 24 CF 964. For Mr. Willis, we have been trying to line up an inpatient treatment program, and we've been working with an outside contact trying to get him into a private inpatient in St. Lucie. It doesn't look like that's going to happen, primarily because of insurance. We've immediately pivoted in trying to get something local as far as placement with 12 Oaks, which does accept your insurance. So I was hoping to have input or approval from 12 Oaks by today to go ahead and move forward with entry of a plea, because that's the only thing that's holding us up for Mr. Willis. So I'm left in a position that I must ask for a continuance until September 9th. But if I get the approval for 12 Oaks tomorrow, I would likely be emailing the court trying to find some time to get in front of the court.
Well, you can do it any Thursday at 12:30.
I'm
You
aware-
don't need my prior approval, just,
Yes, sir. I want to make sure that we keep hands on this to get Mr. Willis out of jail as quickly as possible.
Good.
Because it's going to be a probation agreement with Inpatient, is my discussion with the state.
Right.
So as soon as we line up placement that would likely be bars to bed, then I will certainly inform the court, and we will try to get it back on an earlier docket.
so Mr. Willis, I'll see you no later than September 9th, but again, I've got a week from today. If you get the okay and the state agrees to the plea, I'll see you a week from today. Okay? Thank you, sir.
I'm good. I know that. I know. Okay.
Thanks, Mr. Willis.
Thank you.
And Judge, if we could pass Mr. Wright for about 10 minutes, I need to discuss something with the state.
Okay. Hello, Mr. Nopes.
Good morning, Judge.
Good morning, sir.
Judge, I filed a motion to reinstate bond on the two cases that I have.
Yes, sir.
23 CF 0, I guess 23 CF 90, and then 22 CF 2789. There's actually two other case numbers that I think that Mr. Klein represents him on, 24 CF 1360 and 24 CF 642, from what I could see. Am I correct?
Yes, Your Honor, I had filed a motion to reduce Mr. McNamara's cash or professional bonds in the cases I have him on. Also, there was a bond revocation on a $10,000 cash or professional bond in 24 CF 642. Mr. McNamara would be requesting the court to reinstate that bond, but then reduce that to a $10,000 signature bond. There is an incorrect statement in the motion I filed. I wrote that Mr. McNamara would be living on Took Street. He's actually corrected that. He would be living at 301 South Avenue in Apartment 1
Okay.
in Fort Walton Beach. Admittedly, I'm kind of tagging along with Mr. Nopes here. His cases have been pending for longer than mine have. Mine are relatively new. I can tell the court I represented Mr. McNamara in the past. He is a resident of the area. His mom is here. His mom's actually involved as an alleged victim in a case that I have. His brother just entered a plea on Monday, so he is a longtime resident. The only reason I didn't write lifelong is because I wasn't 100% sure if he's been a lifelong resident, but he's definitely baked into the DNA of Fort Walton Beach. I can tell the court that his primary concern right now is his girlfriend. She has pressing medical issues, and she was scheduled for surgery in late June. I think that's been pushed off, and that's the primary reason Mr. McNamara is asking the court to consider reinstating and reducing his bonds on my case, or cases, is his concern for his girlfriend. So I normally, I'll be the first to say, like, you know, that's, I'm not going to sit here and try to pull on heartstrings or anything, but I mean, that's the reality of the situation with Mr. McNamara. It's his concern for her, and talking with him, I have no doubt that his concern is genuine on that point. So I don't know what else the court could do. I believe he's already on pretrial services. My cases are so new, I don't even have the discovery of one of them. So all I can do is ask for the court to consider reinstating and reducing the cash and professional bonds on my cases, and however the court handles Mr. Nopes' motion,
Okay. Mr. Noakes?
Judge, I concur with the remarks of Mr. Klein. He's worried about others in his life. He's trying to help. Judge, he's not going anywhere. I mean, he's Fort Walton Beach is where he's at. He's old. For as long as I've known him, he's been in Fort Walton Beach, and if you look at the records, you can see Fort Walton's where he's from and where he hangs out. So we're asking the court to reinstate his bond so we can get him out of jail so he can take care of his girlfriend.
Okay. Yes, sir.
Yes, Your Honor. I mean, first I want to state the court, or the state, understands and recognizes the concerns, I think, for his girlfriend. However, in this particular instance, Judge, you're going to see 4 case numbers. You're going to see a 22 CF 2789 case. You're going to see a 23 CF 90 case. You're going to see 2 24 cases. One of those cases I want to point out is a fleeing and attempting to elude where he was going 60 miles an hour in what I believe is a residential area that I think the max is 35. Your Honor, I also want to point out that this defendant has already been given a chance on a couple of these cases. In 22 CF 2789, he was out on bond, commits the 23 CF 90 case, it gets revoked. He was then given a signature bond by stipulation from the state that allowed him to get out on December 14th of 2023. So not only did he receive the benefit of being given that bond, but he was actually given a reduction of a bond to a signature bond. So exactly what he's asking for now in these cases has already been done. And we've seen that Mr. McNamara is unfortunately not willing to follow the laws of this state. In this particular instance, in 24 CF 642, it was a fleeing and attempting to elude charge, meaning that he was trying to evade police and trying to evade apprehension. Therefore, Your Honor, we respectfully request that because of these new law violations, because of how many open cases he has, and the fact that he's been given an opportunity to follow the law before and he hasn't done so, that the bonds remain revoked in 22 CF 2789, 23 CF 90, and 24 CF 642, and the bonds not be reduced in 24 CF 1360, Your Honor.
Thank you. Mr. Noakes, anything else?
Judge, I believe that the state's resting a vast majority of their argument on this new case, the plea and attempted elude, which is 642. Mr. Klein knows the facts of that case, and there may very well be some misunderstanding.
So, Your Honor, on that, particularly on that fleeing case, the identification of Mr. McNamara literally came about based on the pair of shoes. Like, that's it. Like, the actual person driving this motorcycle was not detained that day. There was no, at least not in the police reports, there's no reference to, I personally identified Mr. McNamara. I mean, Deputy Glenick had to go and talk to somebody named Robert Palmer, who gave the name of Chad, may have been driving this particular vehicle. I can tell the court Mr. McNamara stridently disputes the facts in the fleeing case in particular. This is a situation, Mr. Levy, who's on the later docket, has a similar situation, but it's a slightly different, but it's both involving motorcycles, both involving no arrest on the day in question. So Mr. McNamara, I mean, he's innocent until proven guilty in that case. In a situation where I have not deposed the officer yet, he's definitely on my list of people to depose, but I can tell the court that the identification in that is a key issue.
Wait, hold on one second. As I look at the probable cause of the affidavit that's attached to that, it states the defendant admitted to riding the motorcycle, but denied running from law enforcement.
Your Honor,
Hold on. Mr. McNamara, I just don't want you to say something that'll hurt your case.
I understand.
You know, the breadth of the paperwork I have, it's from different time periods. I mean, when I was doing my homework, some of this is old homework that I had from before. You know, the affidavit that talks about entering a home by force while inside, $3,567 in property coins. Then I've got, and these are just what I've highlighted in different affidavits. The other one, riding the bicycle, the methamphetamine, the charge of that, the accusation. The defendant stated he was a methamphetamine and fentanyl user. And then again with the alleged admission and also the allegation that you were actually wearing those shoes at the time the officer stopped you. It's not a close call for the court. Respectfully, your motions to modify bond are denied. I have concerns for the safety of the community. Well, I see Mr. McNamara on September 9th.
Well, two things, Your Honor. He is on the arraignment docket for today
Good.
in 24 CF 1360. There is a three-count information. We will waive the formal reading, enter a not guilty on that, and ask that everything be put on the September 9th docket. I can tell the court that we are trying to work on a resolution for all of those cases, so there's a chance you'll see Mr. McNamara before September 9th.
Good.
And in preparing for today's case, Madam Clerk, 18MM117 is currently opened in Benchmark. This is a misdemeanor case that I think was reopened only because a notice of appearance was inadvertently filed in it, because he was sentenced on that case to a county jail sentence, I believe in 2019, but I just wanted the clerk's office to be aware there's a random old misdemeanor case that probably should be closed officially in Benchmark.
Okay. Thank you. Thank you, sir.
Judge, I show that we're actually coming back for status on August 15th.
Okay, is that
Yeah, the state's
Still on?
actually,
making some offers that you think may be accepted?
right.
Okay, then I'll see you on August 15th. Thank you.
Next, we can take care of some of the ones Jennifer Rodriguez, Mr. Cox.
Good morning. This Ms. Rodriguez is receiving one count of the information, Your Honor. Will be entered a not guilty.
Okay, hold on one second. Let me pull that document.
I understand. Your Honor, my client is asking if there is a current offer in this
Okay.
possession of controlled substance.
Good. Is there, to the state, an offer to Ms. Rodriguez? It's 24 CF 1354.
This is ASA Snell's, Your Honor. Hold on, I can check to see. Your Honor, it would be an adjudication of guilt, 36 months probation, substance abuse evaluation and treatment recommended, 50 hours of community service work, maintain gainful employment, or submit 3 applications per week, Your Honor.
Okay.
Your Honor, if I may, can we pass her up for this afternoon and I can get a plea agreement and have a meaningful discussion back there?
Sure. Ms. Rodriguez, I'll see you this afternoon. You want to bring her back at 1:30 or 2:30?
We could do the 1:30, Judge.
Okay.
I'll be good.
Ms. Rodriguez, I'll see you then.
Thank you so much.
Thank you, ma'am.
Thank you.
Yep.
Mr. Noakes has one with out of custody.
Okay, Mr. Noakes?
Judge, I've got Joe Petit, the state.
Thank you.
Judge, the state did make an offer this morning. I was able to convey that offer. Mr. Petit and I need some time to discuss, so what's our next date that we can have?
Okay, September 9th is pre-trial.
Maybe I did. We're hoping it could be a resolution. Could we set it for the second week in August? The second miscellaneous week?
Why don't, if y'all enter into a plea, just set it any of the days. You can set it any Thursday at 12:30, if you want to do that.
And for Mr. Nopes' knowledge and this court's knowledge, I did file a null process to count one only. I don't know if the clerk got that, but I did file that as well. Only on to count one in 23 CF 813.
Okay. So, Mr. Petit, I'll see you no later than September 9th. But if you wish to enter a plea before that date and avoid about 300 people, Mr. Noakes can set it for a hearing, okay? Thank you.
And then, Judge, the other case that I showed that we put on for status, I don't think we required my client to be here. was Mr. Carlos Sambulin.
Yes, sir. You waived his appearance today. Yes, sir.
We're set, I think the courts marked this as a trial for September, so we were just trying to, I think, the court wanted to put it on status just to see kind of where everybody was at.
Okay, so we're ready for trial next cycle?
I'll get you an order so we can get the witness transported from DOC.
Good, okay.
Judge, and once they get those witnesses here, I'm going to want to take their deposition, but it won't be hard to do. I mean, it's just a matter of, I mean, we can just notice it, and if they're there, we just show up with a court reporter, or recorder will take their deposition.
Good.
And I would ask that the state would make the victim available, because he's been one of the problems we've had. We've not been able to find him, but they represented to the court that he had contacted them and that he was in fact here and available. So I want to make sure that I've got current contact information for the victim.
Okay.
I spoke to him myself on the phone.
Good.
But it doesn't change the fact that I haven't gotten a new address.
Yes, sir. Make sure you stay in touch with Mr. Nopes and make him available for a depo, or if that's what he's seeking.
I would like to take his deposition, but the state needs to amend their discovery.
Gotcha.
All right, thank you.
Thanks, Mr. Nopes.
Next, we have Crystal Setzer on 130 docket, just unrepresented.
Hello, Ms. Setzer. Ms. Setzer's case is 24 CF 1369. Ms. Setzer, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
$100.
How long have
$400 a
you-
month.
I'm sorry?
$400 a month.
Okay, I do appoint the public defender to represent you. Mr. Koch is approaching on your right.
You got three other?
Yeah, and JD.
Okay. Okay. Your Honor, received the information, will be entered not guilty on all counts, waive formal reading, and request to be kept on this 9/9 docket.
So we have two cases coming up for plea day on 8/15. I don't know if you guys want to move this to that date, because they're all three on the same date.
Certainly, if we could put it on the 8/15, if we get a resolution on everything, Your Honor.
Okay, so have this new case on for September 9th, but then have a status on the 15th, August 15th? Okay. So, Ms. Setzer, I'll see you no later than August 15th, okay?
Yes, sir.
Thank you.
Yes, ma'am.
Next, we have Nicholas McNabb. Mr.
Thank you.
Your Honor, this is Mr. McNabb and 23 CF 468. There is a one-count information. We will waive the formal reading, enter not guilty plea. I believe Mr. Gomez is going to have it.
Your Honor, this time, so Mr. McNabb in this case with these set of facts has been sentenced, I believe, to around 18 years in federal, as a federal sentence. So at this time, the state is going to be dismissing 23 CF 468, Your Honor.
Okay, Mr. McNabb, your state case of 23 CF 468 is dismissed.
All right, thank you.
Thank you, sir.
Next, we have a chance Ruby for Mr. Koch.
You want to know what? Just hold on to that. That they filed on these, in the charge, okay? Your Honor, this is Mr. Rubink to my left. Will be entering a not guilty to count 1, waive formal reading, request it be kept on the 9-9 docket. My client also has another open case in this court, Your Honor. At this time, there's not a global, but certainly, if we do reach a global resolution for everything, we could set a court date earlier than 9-9.
Mr. Rubin, I'll see you no later than September 9th, but if the state offers you something that you want to accept as early as next Thursday, then I'll see you then. Yes, sir.
I just have one thing I want to say if I could address.
Just know that everything's being recorded.
Yes, sir.
If you say anything factually about your case, the state's to your right and it can be used against you.
Yes, sir, I'm ready for it. I said, Dear Honorable Judge Brown, I would like to address the court to resolve this matter today if that's possible. I'm willing to admit to the charge before this court with the term of a simple probation or a simple county jail sentence with all credit for time served. I believe we can resolve this matter before this court today. If I could ask the court to let me go back into holding to allow the state to weigh the options and to print me up a plea offer with these stipulations, I will sign and get this case off of your docket.
Okay?
I'm ready.
To the state.
Yes, so today, there's 2024 MM2255. That's getting transferred to circuit court.
Okay.
Once we have that case, then we will make a local offer on it at that point.
So at this point, you are not accepting Mr. Rubik's offer?
No, sir.
Okay. And you're not making a counteroffer?
He's got this theft charge, he's got possession of a controlled substance case, 24 CF 1289, and then he'll have a third case, which will be another felony petty theft. So we'll have 3 felony charges at that point. And then once I get all 3 and have the score sheet, I can make an offer at that point.
Okay. You think you can pull that together before next Thursday?
Next Thursday would be,
So I got family, I gotta get home.
I understand. Just as soon as the state offers you something that you want to accept,
I'm willing to accept
Then-
anything right now.
well, and they aren't offering anything at this point, then Mr. Koch can set it for hearing as early as a week from today. So the underlying case is set for September 9th, but if the state offers you something that you want to accept before that, Mr. Koch can set it as early as next week, and we have a lot of dates after that before September 9th.
Will I have another court date August 2nd?
You don't at this point.
Okay.
You don't at this point, no, sir. Okay? Thank you.
I will when I get off.
Hello, Mr. Weir. Good morning, I think, still. Yes, sir.
Jason McKinney for Mr. Ware in 24 CF 1335. We had passed it over today to see how this case was going to be charged. May I have a moment, Judge?
Yes, sir.
Judge, we would acknowledge the receipt of a one-count information, waive its formal reading, enter a plea of not guilty. This is already scheduled for September 9th for pretrial. I was just telling Mr. Ware that now that we have the third-degree felony charged, I'm going to work with the state in trying to secure an offer. If we can reach an agreement ahead of September 9th, I'd like to bring this back on an earlier date.
Absolutely. Mr. Ware, I'll see you no later than September 9th. Thank you. Thank you. Okay, thank you. Hello, Mr. Whitfield.
How you doing, sir?
Good, how are you?
I'm pretty good.
Mr. Whitfield, hold on. I don't want you to say anything that'll hurt your case, so let's talk. Let me ask you some questions.
Yes, sir.
First off, this is 24 CF 1397. Mr. Whitfield, do you wish for me to appoint the public defender if you qualify financially?
That's exactly what I was about to say.
Good.
First appearance. a
How
month
much
ago.
money do you average making per month?
0.
How long have you been unemployed?
I've been homeless for about two years.
Okay, I do appoint the public defender to represent you. Mr. McKinney's approaching on your right.
Thank you.
Does the state have an offer for Mr. Whitfield?
And this is set for
16 on my
arraignment.
130 docket.
Jeremy James Whitfield, 24 CF 1397.
6 months in adjudication.
Where's my probation? Oh, yeah, I'm thinking I wasn't on probation. And with the bond shooting, I was on $100 with no charges. So I'm not thinking it's reasonable if you can.
Judge, we would acknowledge a receipt of a one-count information, waive its formal reading, enter a plea of not guilty. I'd like to get a file open so I can go meet with Mr. Whitfield at the jail, discuss the offer, discuss the bond, and see where that takes us.
Okay. Mr. Whitfield, I'll see you no later than September 9th, but if you decide you want to accept whatever the state ultimately ends up offering you, Mr. McKinney can set it for a hearing before that date.
I expect that we would see the court prior to September.
Good. Okay. Thank you, Mr. Whitfield.
Thank you.
Judge Jerry Bowman on the 9 o'clock docket was fine.
Okay, thank you.
Today is July 18th. Your Honor, this is Mr. Bowman. He is present today in 21 CF 555. He's going to be entering a plea in that case. As part of that plea, Your Honor, he's also going to be entering a plea in 24 MM 1638. That is a criminal mischief under $1,000. The agreement in the 1638 case, Your Honor, is that Mr. Bowman would be sentenced to time served. He would be ordered to pay $2,025 in restitution to AJ's, the restaurant AJ's. That restitution amount will be rolled into the supervision period in 21 CF 555. He would be assessed court costs, misdemeanor court costs on that 24 MM case, a $50 public defender fee on that case. In 21 CF 555, Mr. Bowman is going to admit the violation. The agreed upon disposition is that he will be sentenced to 90 days in the county jail with credit for all time served. The state will stipulate that that sentence has been served in its entirety. Technically speaking, the probation is being modified to include the 90 days and then reinstating him to the original terms on the 555 case. The term date on that case is, I believe, 2031. So he will have to, all of the original uncompleted, original prior terms of supervision, including the GPS monitor, will be reinstated to his supervision period in the 555 case. He would be assessed a $100 cost of prosecution, a $50 application fee, a $100 public defender fee in that case. I believe that's it. Is that, did I miss anything?
I don't believe so.
May I approach?
Yes, sir.
And I have a score sheet, Your Honor. Mr. Bowman has signed this plea agreement.
Thank you.
No objection to that score sheet.
So, Mr. Bowman's going to, he'll serve 90 days with credit for time served of the, in jail, and then he comes out and his probation continues after that.
Yes, Your Honor. And the reason why we, so the intent for Mr. Bowman here is he's been working to transfer probation to Georgia. He also has a period of probation in Georgia. His mom has just struggled to find an acceptable address, and I talked with Ms. Barrickman, and it just, I don't know. I feel wrong having a client just sit in jail when all we're trying to do is arrange a transfer that he still has to go through the transfer process anyway.
Okay.
So,
And it's an adjudication of guilt on both cases.
yes, Your Honor, he was previously adjudicated of the felony in this case, the 555 case.
Mr. Bowman, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand out. Mr. Bowman, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes, Your Honor.
Mr. Bowman, I do accept your plea. You're adjudicated guilty in the misdemeanor, sentenced to credit for time served. You'll need to pay the court costs in that case, $50 public defender's fee, restitution of $2,025, but that will be paid during your, does he want all the financials, Mr. Kleins, to be rolled over?
I think that'd be the best idea. Yes, Your Honor.
So you can pay all of those in your other probation?
Yes, Your Honor.
Sentenced to time served in that misdemeanor. In the 21 CF 555 case, adjudication of guilt, your current supervision is modified with the original terms and conditions. And it's modified so that you'll spend the next 90 days or at least with credit for time served in the Okaloosa County Jail. You need to pay the $100 VOP fee, $150 public defender's fee.
And Your Honor, the reason why the state is stipulating to that entire sentence is being served is Mr. Bowman's been in custody since April 1st. So,
okay. And right, and the state stipulates that you've already served all of those 90 days.
and the last thing, just for Mr. Bowman's benefit, I believe that he's going to have to remain in custody until that GPS monitor is attached. But the jail will probably make that happen today or tomorrow.
Okay. And it's a downward departure, correct?
Yes, Your Honor.
Okay. Thank you, Mr. Bowman.
Good luck, okay? I'll call your mom later.
Last one we have is Wendell Wright, which Mr. McKinney's just talking to him about last.
Yeah, there's one case we could address. I spoke with Mr. Koch. Mr. Patton is not present, and he has not had any communication with him. He was scheduled for 9 o'clock, and so the state would request a KPS, Your Honor.
KPS will be issued for Mr. Patton.
And then, Your Honor, may I approach real quick?
Yes, sir. And the fiscal hearing judge will determine the bond.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Yes, sir. Thank you. Welcome back.
Good morning, Your Honor.
Good morning.
How are you today?
Doing well. How are you?
Yes, I can be today, Your Honor.
Mr. McKinney, where are we on the case?
Have you had a chance to review this plea agreement?
Yes, sir, I have.
No. Okay, you don't have to say it on the record, just talking to me. Okay. Yes, sir. Yes, sir. We have reached an agreement, Judge. I'm writing in one term before he signs this, which would be the imposition of sentence on August 12th, which is Your Honor's next available miscellaneous date at 9 a.m. And that so that I may research a matter for Mr. Wright related to his classification primarily at Department of Corrections. The agreement that's been reached with the state and Mr. Wright on the remaining two cases, which is 2020 CF 2804 and 2021 CF 1772, would be a plea as charged in both of those cases, time served for the misdemeanors with adjudications. On the felony counts, he would be sentenced to 5 years Department of Corrections with credit for all time served. All cases and counts concurrent. Also concurrent with 20 CF 3187 and 21 CF 1776, which is the case where he's already under sentence and there's a pending appeal.
Okay.
20 CF 3187 is technically before the court for sentencing. It's part of this agreement that it would be a 5-year Department of Corrections sentence concurrent with everything else.
Okay.
That's been discussed with Mr. Wright, including the imposition of sentence on the 12th, so that I may answer his questions, not about this agreement, but primarily about classification at Department of Corrections.
Okay. And so, any other terms? Court costs,
Standard
VOP
court
fees?
costs. Standard court costs would be $615 and $515 in the second case, total of $250 cost of defense. The court would need to impose, at the time of sentencing, those $615 and the $150 cost of defense. In the other case, which is technically before the court for sentencing, which is the 20 CF 3187, we would ask for the imposition of sentence at the same time on the 12th of August.
Okay.
In 20 CF 3187.
Yes, sir.
To a concurrent 5-year term.
Okay. And so Mr. Wright will remain in the Okaloosa County Jail, so we don't have to worry about him absconding or not showing up when he's supposed to be there?
Correct, and he is already under sentence in the 1776 case, and he would remain in the Okaloosa County Jail until that date, primarily so that I can research that matter for Mr. Wright.
Okay, good, thank you. Please.
I'm sorry, the 2804 case does get the minor fee for the child neglect charge.
How much additional is
It's
that?
$150, it's $151.
So that's an extra $150. Does that change your opinion on anything?
No, sir.
Okay. Mr. Wright was just making clear that in the 20 CF 3187, which is the case before the court for sentencing, the state has agreed to a concurrent 5-year sentence in that case as well to make it match this agreement for these two case numbers.
Okay.
May I approach
Yes,
the plea
sir.
agreement?
Thank you. Mr. Wright, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor, I do.
Thank you, sir. You can put your hand down. To the state, is this going to be a downward departure, or is it?
I would
Okay.
anticipate it would be, and the state would provide a score sheet at the imposition of sentence.
Okay. Mr. Wright, first, did you understand everything that Mr. McKinney stated today on the record about your case and about your sentence?
Yes, sir, Your Honor, I do.
Okay. Are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
Not yet.
Okay. How far did you go in school?
12th grade, Your Honor.
Did you read the plea agreement?
Yes, sir, Your Honor.
Do you understand it?
Yes, sir, Your Honor.
Did you discuss it with your attorney?
I did, Your Honor.
Did he answer all of your questions?
So far, yes, sir.
Are you satisfied with his representation?
Yes, sir, with this plea agreement, yes, sir. Yes, sir.
Did you sign the plea agreement?
I did, Your Honor.
Has anyone forced, threatened, or coerced you into entering the plea?
No, not this time.
Okay. Has anyone promised you anything other than what was stated today on the record and what's in the written plea agreement?
No, sir.
Okay. Mr. Wright, I do accept your plea. I find, how far did you go in school, Mr. Wright?
12th grade.
Okay.
I graduated, Your Honor.
Good. I do accept your plea. I find that you are alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. So I'll see you back here on August 12th at 9 o'clock for the imposition of that sentence.
Thank you, Your
Okay.
Honor. You have a good day, sir.
Thank you, sir. You too.
Yes, sir.
And Madam Clerk, that would be placed in 20 CF 3187, also on the same date and time.
Mr. Koch.
Judge, may I call a quick case just to readdress for Edwin Sanders, just for clarification for probations?
Okay.
We pled out Mr. Sanders. He had that 23 CF 1862 VOP. We admitted to the violation. That original term was revoked and termed. And of course, the sentence we outlined in the plea form, that's the new terms of the new probation. Does that clarify everything?
Needs to be same terms and conditions.
Same terms?
Original terms and conditions reimposed.
You did, you got that in there.
They didn't announce it, so I hadn't circled it, but I can.
That's what we need.
Mr. Koch, is that what, and I wondered about that, but it wasn't stated. That was the original agreement?
So the 23 CF to revoke the original probation and the new terms on that plea form, the 24 hours community service, the substance abuse, gainful employment, those are the new terms of probation and the costs.
But that's on top of the original.
But are you
conditions?
reimposing the original terms, like the monetaries and?
Oh, yes, I'm sorry, just for the monetary, yes, reimpose, yes,
Just mine.
yes,
Okay, and your client knows that?
yes, the original.
Okay, then yes, ma'am. You need to make sure you say that, okay?
Yes, Judge, thank you.
Good. Thank you.
And I do have 2 cases on the morning docket that unfortunately they're not present, if I can call that, Judge.
I have Nicholas Simmons.
Yes, Your Honor, we had a plea form ready to go this morning. Unfortunately, I did not see my client.
Okay. Why don't we wait until this afternoon?
Okay.
Just bring it up before you leave, okay?
Will do, Judge.
Madam Clerk will hit us up at the end of the day, but before you leave, if you'll bring those up.
Certainly.
Okay? Good.
And that's all I have for.
Okay. So we're in recess until 1:30. Thank you. 12:30. 12:30, that's right, pre-trial. Got it.